we get started, we're expecting a few more people, but they'll filter in, and we'll kind of have an informal discussion here. So I'll just introduce myself quickly for those who are unfamiliar. My name's Mark Mancini, and I'm the National Director of the Running Meat Society, and we're just really pleased to host this discussion today with David French, who's here. I'm going to kind of turn things over very quickly here to Leonid Sirota, who is co-blogger of mine at Double Aspect, noted Canadian constitutional law professor, currently teaching in New Zealand. And he's going to do a bit of an introduction for David and set the stage for the conversation to follow. So Leonid, you can take it away.
Thank you, Mark. It's a real pleasure for me to introduce David French. Real pleasure as just a fan and admirer of his writing and his podcasts. David French is currently senior editor at The Dispatch, where, among other things, he co-hosts the Advisory Opinions podcast, which is a great way to keep up with constitutional law in the United States in particular, but legal nerdery more generally. I think I've listened to every single episode, and I will continue listening to every single episode. So if that is a recommendation that counts for something, there you have it. It's really great, and he also writes newsletters and other things for The Dispatch. He's also most recently the author of a book with a cheerful title, Divided We Fall, about the prospects of secession in the United States. Before coming to The Dispatch, and before that to the National Review, and so before becoming a journalist, Mr. French graduated from Harvard Law School. He practiced law in a variety of settings, in private practice in New York and in Tennessee, and in public interest litigation, focusing on freedoms of religion and speech, including as the president of the Foundation for Individual Rights in Education, FIRE, and it's a wonderful organization, which we are, I think, missing in Canada when we look at the state of thought conformity in Canadian higher education. Mr. French also was a JAG officer in Iraq, and he taught law at Cornell as well. So he has been in more different parts of the legal profession than most people. And that's one reason, among many, why we are privileged to be hearing from him today. Lastly, I should also mention that Mr. French has, and I think that was without looking for this at all, become a symbol of an approach to politics that some people seem to resent and deprecate as being too imbued with old-fashioned notions of self-restraint and decency. And one of his detractors, in fact, has gone so far as to call it David Frenchism as part of a denunciation. And for my part, what this makes me think of is Rudyard Kipling's poem, If, and its opening lines: if you can keep your head when all about you are losing theirs and blaming it on you. That seems to have been written about Mr. French. I think he embodies many of the virtues about which Kipling wrote, as well as having a fascinating and accomplished career. And we are very fortunate to be hearing from him today.
Well, thanks a ton for that introduction. Whenever I hear all of the different winding paths that my legal career has taken, that's a very nice way of saying something other than he still doesn't know what he wants to do when he grows up. I think I've done about everything in the practice of law other than divorce law at this point. This is a real privilege. I want to talk about the rule of law. I want to talk about the indispensable role of lawyers and of good lawyers and good judges and preserving in the United States, our Republican form of government. And I can think of no better timing to do this than now, just after we have come out of what is really an unprecedented effort to overturn an American election that resulted in an unprecedented effort to, well, certainly, I think it's fair to say unprecedented effort to violently stop the peaceful transition of power. And I want to talk about the role in which the American judicial system and American lawyers played in, number one, staving off a cascading series of events that could have fractured our republic. And then number two, are currently playing in an effort to, number one, suppress what looked to all practical purposes to be an emerging violent insurrection on January 6th, and also to correct the vicious and viral misinformation that flowed across the American Republic for week after week after week following the election. And we'll try to draw some larger conclusions by this, but I think there is a case to be made, a book to be written about the aftermath of the American presidential election that says how lawyers saved the United States of America. And I don't think that's hyperbole. I don't think that's hyperbole. And I explain to you why. So let's rewind to the state of being at about 3 in the morning Eastern time on November 4th, early morning hours after the November 3rd election in the United States. At that point in time, if you knew nothing, if you had not been paying attention to tens of thousands of words of commentary and predictions and trends before the election, you would think at that point in time that against all odds, Donald Trump was about to be reelected president of the United States of America in a development more shocking than his defeat of Hillary Clinton in 2016. More shocking because he trailed her and trailed Biden more decisively in the polls. More shocking because on his watch as president of the United States at that point in time was in a recession. It was suffering a wave of death. Unlike we had seen in the United States in 100 years, the United States was bitterly divided in a way that it was even greater than it was in 2016, which was itself an incredibly divisive election. And at this point, by 2 or 3 in the morning, he was, against all odds, leading in a number of states in the polling or in the vote counting that he was not expected to win. And there were a number of people, millions of people in the United States who, in fact, went to sleep late in the night, early in the morning, believing that Donald Trump had won. By the time they woke up the next morning, that belief was shattered, that vote counting had continued. And as the vote counting had continued, Donald Trump had fallen behind. And this is the point almost immediately where a narrative began to lock in with tens of millions of Americans that the election was stolen, that the Democratic machines in major cities had done ballot dumps, had engaged in late night shenanigans to snatch defeat from the jaws of victory. And so this ignited a firestorm in the United States of America. Now, what is it that really happened? What is it that really happened was really kind of expected, predicted, and rather boring. What really happened is it just was taking a long time to count mail-in ballots, especially in large jurisdictions. That's what really happened. Why was this expected? Why was this predicted? Well, we knew two things at once. We knew that in multiple jurisdictions, especially key jurisdictions, like, for example, Pennsylvania, election authorities were not permitted to count mail-in ballots as they came in, or to count mail-in ballots at any point before Election Day. So they were going to have to start counting mail-in ballots as the polls were closing. That's one thing we knew. We also knew that there were going to be a lot of them, far more than normal because of the pandemic. And so this was called in different ways a red mirage, followed by a blue shift. We even had terms for what was expected. And in fact, legislatures had been asked before the vote counting, please change the law to allow counting of mail-in ballots before Election Day so that we would not have this exact situation. In some circumstances, Republican legislators blocked efforts to change the law so that counting could occur earlier. So everything that we knew, when you if you were somebody who was an election nerd, a news hound, a legal nerd, somebody who was deeply following very closely the ins and outs of voting in the 2020 election, knew exactly when you saw the numbers rolling in what was about to happen. When I went to sleep at 2 or 3 in the morning on on the early morning hours after the election, I thought Donald Trump has lost. The numbers, the advantage that he had in the polling and the voting was not enough for what we knew was about to come as the vote counts continued, depending on where these vote counts were coming from. But that was a sliver of the American population, a sliver of the American population. Large numbers were not up with all of this, and we're very vulnerable to a story being told, and that story being told was one of a stolen election. Now, where do you go from there? When you have a president of the United States, you have the most powerful man in the world saying an election is stolen, and you have the Democrats saying, no, it was not. This is all legitimate. How do you adjudicate? How do you adjudicate without resorting to raw political power? Well, here you go, lawyers. This is your role. This is your moment. This is your time. Because in a functioning rule of law based society, what you have is a means of adjudication dispute. You have a means of adjudicating disputes. Now, in a functioning rule of law based society, well, let me put it this way. The key word there is functioning, because every society has a judiciary. A highly and overly politicized judiciary is going to yield overly politicized results. But what is it that was interesting that happened in the American judicial system and in the American legal system between November 3rd and the ultimate recognition and certification of the Electoral College vote on January 6th? What is it that happened that was interesting? Two things. One, obvious, another less obvious, about how the judicial system worked and the incentives inherent in a functioning judicial system worked. So first, judges unanimously, in spite of the fact that judicial appointments and judicial nominations are highly politically contentious in the United States of America, there was not a partisan pattern to judicial rulings that were handed down after November 3rd. Every single Trump appointed judge who looked at the Trump lawsuits rejected the Trump lawsuits. Every single appointee of a Democratic judge who looked at the Trump lawsuits, and when I say the Trump lawsuits, I mean the big ones, the ones that were material to the outcome of the case, who looked at the lawsuits, rejected them. Every judge who was an appointee of a Republican president, not named Trump, rejected these lawsuits, not because of political reasons, but because of legal reasons. They were deficient on their face. Now, for a lot of Americans, looked at that and they rejected that, and they said, well, that's evidence of a lack of courage. It's evidence of a lack of cowardice. There was still an enormous trust deficit in the United States. But for the actual mechanics of the lawful exchange of power in the US and the operation of law that allowed for the duly elected president of the United States, Joe Biden, to take office, at every stage, there was a response by the American judiciary, regardless of the appointee, of the nature of the appointing or the identity of the appointing president, rejecting frivolous lawsuits, rejecting meritless lawsuits. Now, lest we take that for granted, that is not something that you can assume will happen in the course of world history. Independent judiciaries are a precious thing. This is something that you can take for granted. Americans took for granted the idea that the transition of power would be peaceful. We now know we can't take that for granted. We also should know that we can't take a independent judiciary for granted. But that's what worked after November 3rd. But there was something else that happened that was a result of what is evidence of a functioning American judicial system regarding incentives. Now, If you look at the Trump administration or the Trump campaign lawsuits or the allied lawsuits, lawsuits allied with the Trump campaign, one of the things you're going to notice is that with very few exceptions, the leading lights, the luminaries of the American, especially the conservative legal movement in America, sat on the sidelines. One of the most contentious lawsuits in the entire process was a lawsuit brought by Ken Paxton, the Attorney General of Texas, seeking to have the results of other states' elections thrown out for failure to comply with constitutional processes. The lawsuit was frivolous on a number of grounds. He lacked standing. Even if you went to the merits were, it was meritless. What was interesting about that lawsuit? Well, a couple of things. One, Ken Paxton, the Attorney General of the state of Texas, where I'm actually in Dallas right now, in Texas right now, is under investigation, was under federal investigation on corruption charges. This was what appeared to be a blatant play for a pardon. It didn't stop a number of other politicians from signing on to this. Some state attorney generals signed on, a number of members of the Republican members of the House of Representatives signed on. But this lawsuit, which he filed, missed a notable signatory. It was not also signed by the Solicitor General of Texas, somebody who is widely respected in American legal circles as a person, certainly conservative, but a person of real integrity, of real talent. Time and time again, you had a huge segment of the conservative American bar sitting out the efforts of a Republican president to challenge the election results. Why is that? Because there was also an integrity factor here. Certainly, there's also an incentives factor here. In a well-functioning judicial system, the reputation of a lawyer is defined in many ways by the kinds of arguments they're willing to make in court. Whether or not that they could be deemed a reasonable or respectable and a person of serious intellect is going to be defined not by the mere fact that they've just taken a case and make the best of it, but the kinds of cases they take, the kinds of arguments they make. And so we had enough of a functioning system with all of the dysfunction that is still there, it's far from perfect, to create incentives to disincentivize the the leading lights of one entire legal movement from making specious, frivolous, destructive arguments in courts of law. And so from that standpoint, the American system not only worked, I would argue it saved the republic. Because a completely politicized judiciary, because remember, by the time these cases made their way to the Supreme Court, 6 of the 9 justices had been selected by Republican presidents. 3 of the 9 justices had been selected by Donald Trump himself. And a highly politicized judiciary, one that had no regard for the rule of law, but instead had respect for the raw exercise of power or deference to power, such as deference to arguably the most powerful man in the world, the President of the United States. A politicized judiciary would have overturned that election, would have at least overturned the election results in multiple states that were dispositive to the outcome, perhaps then punting the resolution of the election into a divided House of Representatives. And the effects of that would have been catastrophic. If America was enough of a tinderbox that January 6th could happen, that a mob of thousands could gather in the National Mall in Washington, D.C. and charge and storm the Capitol, then a decision by courts to overturn a lawful election on lawless grounds would have triggered a wave of outrage and dissent, probably violence, and probably dissension that could have led to a fracturing of our country. That's how critical the rule of law was in the United States. I wrote about it at the time. I wrote about it at the time when Ken Paxton filed his lawsuit, that if you were signing on to that lawsuit, you were signing on to nation-breaking litigation. Nation-breaking litigation. Yet the rule of law held. So what role has the rule of law played since January 6th, since January 20th, in the inauguration of Joe Biden. It's played a role in, it is currently playing a role in suppressing an insurrection through the operation of the rule of law in the arrest and trial of the Capitol Hill rioters. But it's also, interestingly enough, playing a key role in the in the war against misinformation. Right now, there are multiple multi-billion-dollar defamation lawsuits pending against key American media figures, against American media networks, that, if successful, will establish an extraordinary precedent for financial deterrence against misinformation. One of the things that we have seen is that social media is inadequate to police the spread of misinformation. One of the things that we have seen is that journalism is often inadequate to police the spread or to restrict the spread of misinformation. All too often, you'll see journalists share misinformation, spread misinformation themselves. Also, we know that from siloing, that people are increasingly likely to wall themselves off into their own ideological echo chambers, which will spread misinformation and often refuse to print or to publish rebuttals or fact checks or news reports that contradict the narrative established by a partisan network or by a partisan host or by a partisan website. But what has come in when journalism has often failed? What is coming in when the political process has often failed? When big tech has failed in its effort to prevent the abuse of its platforms to such an extent that they empowered a violent insurrection on January 6th? The good old rule of law. In fact, common law. In the Anglo-American tradition, the oldest elements of law: common law, defamation, libel, slander. So once again, you are seeing highly politicized events, highly politicized and false factual assertions being channeled where? Into a court system, into a rule of law-based system that has already proven, again, not to be perfect, but to be far more functional than the political society that surrounds it, and by the political culture that surrounds it. And, it's funny, I made a transition from being a lawyer to a journalist. And, for years, I was subjected to lawyer jokes. I mean, I've heard lawyer jokes my entire life. And I have to say that there was never a point in time when I was prouder to have a law degree and to be a lawyer. I don't really practice anymore. I've hung up those shingles. Than the way in which then in the post-election contest period, where it was the legal system that is often much derided, that is often much reviled, that I believe literally saved the United States of America. Now, I'll also say this, if you think lawyers are disliked in the US, try being a journalist. If you think lawyers have a dysfunctional culture, the legal profession has a dysfunctional culture, the journalism profession has a far more dysfunctional culture than the legal profession. But I think one of the things that is a critical takeaway from what happened in the United States after November 3rd is that not only did the system hold in a way that preserved the republic, but it also validated it validated not just the individuals in the system and their courage and their commitment to a rule of law, it also validated the procedures of the system itself. It validated rules of evidence that require you to put up or shut up, that devalue rhetoric and emphasize evidence. It put a premium on rules of procedure that can dictate, when do you bring claims? When is it too late to bring a claim? It demonstrated, it validated the rule of law not just as a set of outcomes, but a set of processes. In the last couple of years, I have been called upon to defend something that critics call process-driven American liberalism or process-driven classical liberalism. There are a number of commentators on the far right and on the far left who are attempting to reject small L liberalism itself as too consumed with process, as opposed to social justice or the common good. Social justice is the phrase used on the left, common good, often the phrase used on the right. Both of the words are very fuzzily defined, but often mean sort of the outcomes that we want. Whereas the classical liberal is concerned with outcomes. They're concerned with the common good. They're concerned with social justice, but they're also concerned with the system that creates those outcomes, and that the processes within the system itself should be fair, and the processes within the system itself should be rigorous, and that we do not trust human beings enough to stampede straight to outcome. We don't. We want human beings to be required to prove the worth of a claim before we adopt, and the worth of a claim before we support the claim. And that system itself, I think, was one of the things that it was the processes, not just the outcome. In this case, it was the processes that yielded the outcome, because the challenge to the election, the put up or shut up, there was nothing to put up. There was nothing to support the rhetoric. And the processes demonstrated that. And a lot of people have denigrated some of these outcomes by saying, well, you're not really adjudicating on the merits if you're saying the claim was brought too late. Certainly, that is true. You have not adjudicated on the merits by saying the claim was brought too late. But what you began to see was the fairness and the fundamental necessity of processes saying bring claims within enough time to adjudicate them. So again, this was something that, for example, it wasn't just the processes, it wasn't just the outcomes, it was the processes yielding an outcome that saved us from a fate far worse than what we saw on January 6th, as terrible as January 6th was, and are currently in the process of making the next January 6th less likely. Not to say that the rule of law and the legal system can do that alone. If the culture breaks all around the legal system will eventually break. But for now, the legal system and the rule of law stood in the gap, gave us an opportunity for our political culture and our general cultural to hopefully heal. We'll see if it does, but the lawyers gave us a chance, and that is not nothing. All right, I'd love to answer some questions.
That's great. Thank you, Mr. French, for that. Really great stuff. Let's maybe start with Leonid, I think, wanted to pose a question, and since he introduced you, we'll give him the privilege of doing that first. So Leonid, go ahead.
Thanks, Mark, and thanks, Mr. French. It was really fascinating and very thought-provoking comments. So I wanted to ask about the law of defamation. So you're a free speech advocate, and I think for a long time there was a sense that people, both in the United States and elsewhere, who were on the free speech side were very suspicious of the law of defamation. You may know that all the other English-speaking countries, their judiciaries have been urged to adopt the New York Times versus Sullivan standard for the law of defamation, and they all have rejected it. They have all said in various ways that this is an American idea that is not really fit for our legal culture. And as you have been saying today, actually, the law of defamation has maybe a very important role to play in the legal and political culture in which we find ourselves. I'm thinking of a case back in the 50s in Canada where a woman was accused of being a communist and sued for defamation, won that case, and a great Canadian legal scholar and lawyer, Frank Scott, wrote an article saying, oh, this proves that the law is a bulwark against McCarthyism and that we can have honest discussion in society. So I was just really curious to hear you share some thoughts on the role of defamation versus free speech, and how maybe your thinking has maybe changed or not.
Yeah, that's a great question. And I would say that my thinking has not changed. The facts changed. So here's the way I'd put it. I am in American constitutional philosophy, I'm considered an originalist. What I'm looking for when determining what a text means is the original public meaning of the text. And now there's not a lot of literature, honestly, about the original public meaning of the First Amendment. But one of the things that there's an enormous consensus around is that the freedom of speech that was protected in the First Amendment, the phrase the freedom of speech did not include defamation. That was not a liberty protected by the First Amendment. And what we've had an awful lot of litigation about is what's the standard of proof for defamation? How does it shift? Does it change depending on the identity of the plaintiff? So in the US, if you're a public figure, this New York Times v. Sullivan standard, you're going to have a harder time making a defamation case than if you're a private figure. But for both public and private figures, there still is a viable defamation doctrine. And I looked at it, and I've written about it at some length, and I've described this defamation doctrine essentially as guardrails. And the guardrails against a falsehood. And the guardrails are higher and stronger if you're a private entity. The protection sort of for your reputation, protection of your, protection against defamation is higher and stronger if you're a private figure. Less so for a public figure. And I think that's the right balance. I think the New York Times v. Sullivan balance, this public versus private figure, is generally the right balance. And what we saw in the election contest was a couple of things at once. One, we saw an enormous wave of falsehood poured out upon what I believe, and we'll see how how this plays out, what I believe are private entities that will be deemed private figures for the purposes of defamation law. Who knew Smartmatic or Dominion before the election? These were not, this was not household names. And it cannot be the case that the defamation itself makes you a public figure. And so I think that the concern that that free speech advocates have is often for the abuse of defamation law as a means of suppressing criticism. And we have in many states, we have an important legal protection against that. And these are anti-SLAPP laws. So SLAPP litigation is SLAPP stands for strategic lawsuit against public participation. And this is when somebody tries to bury you in litigation to shut you up. And anti-SLAPP laws allow you to go through a summary proceeding early in the lawsuit to not only dismiss a case, but get attorney's fees so that you have this ability to respond rapidly to frivolous defamation litigation. It's an important tool. But I think from the beginning of the American Republic, the idea that there is a concept of defamation, it is very real, it is very viable, and it's more difficult to establish the more prominent you are as a public figure. I think I agree with the arc of that precedent. But what happened in 2020 and moving into 2021 was real defamation was committed at scale. And I have spoken to many other prominent First Amendment activists who have long been worried about the abuse of defamation law to suppress free speech, who have again and again and again said, oh, well, if you want a textbook example of what actual defamation looks like, here it is. I mean, this is almost like law school case study stuff. And so I think that that's something that is, my view, honestly, is that absent defamation law, it is difficult to have a truly effective marketplace of ideas. That is an important element of a marketplace of ideas is the restriction on defamation. The question is what standard applies depending on the prominence of the public figure. And I think we've got it largely right in the US.
Okay, thank you. We've got a few questions here. If you want to ask a question, just use the Q&A function. So I've got 3 questions here from Anonymous.
Okay.
Let's go. There's 2 of them here, David, that I think are kind of connected. So so we were talking about process-driven liberalism, and so the question is, aren't values embedded in processes, legal processes or otherwise? Who decides those values? And then are those values not political? And then relatedly, the questioner asked, by your own argument, if Trump had appointed all the relevant judges and those judges happen to rule in his favor, should we abide by the process nonetheless and accept the judicial decision to overturn the election? So maybe a bit about the.
Okay.
Yeah.
So there are value. This is one of my something I've written about quite a bit. Look, there are values laden within these processes, laden within them. So, for example, due process itself is a value-laden proposition. The idea that there is a moral argument that there should be a process before punishment is a value-laden proposition. It's also a value that's foundational to the best aspirations of our republic. And it's also a value that I've not heard a convincing argument against, to be honest. So yeah, these processes embody values, or they're product of values. And so no one would say, and no one should say, that the processes are value neutral. They can have neutral application. In other words, that they should apply equally to all. But no one should say that, for example, due process or the rules of evidence are value neutral propositions in and of themselves. In that circumstance, I've long argued that, in fact, for people who say, wait a minute, I want our legal system to be more oriented towards the common good than proceduralism. And my argument is proceduralism is in the common good, that the equal protection of the laws, equal access to, for example, public facilities for free speech, due process rights, the right to be free from cruel and unusual punishment, unreasonable search and seizure. None of these things are value neutral. And the neutral application of those values is itself a value. So I agree with you that they are laden. And how do we decide? We decide those things ultimately through a democratic process. They were initially ratified as part of the Bill of Rights. They can be undone. You can amend the United States Constitution. I would hope and expect that we won't, that those values are embedded in American culture enough to where they're untouchable to a large degree, not incontestable at the edges, but untouchable at the core. And I think they largely are. As far as the second question regarding, had there been, say, 9 Trump appointees and had they just completely disregarded the results of a democratic election, would that have been grounds for refusal to abide? Let me answer it like this. Well, let me say this. I think, number one, yes, that would have been grounds for refusal to abide. And number two, as a matter of fact, that is what would have happened. I think as a matter of fact, that is what would have happened. As a matter of fact, that's why I said this was potentially nation-breaking litigation, was that you had the combination of a lawsuit so frivolous with remedy so drastic that our republic could not have survived a granting of that remedy. It wouldn't have survived it. Would the people of the states that had voted, especially the states that had voted overwhelmingly against Donald Trump, not the states that had been very, very close, but overwhelmingly against Donald Trump, would the governors have submitted to the authority of the federal government in those circumstances? I think it's very doubtful. I think this was a moment. It's one of the reasons why I was so harshly condemned these lawsuits, is that the practical result of them, the practical result of the argument so frivolous, seeking a remedy so extreme, was nation breaking. And we should be thankful, incredibly thankful, that the justices unanimously had, and time again, or at least without recorded dissent, I should say, were refused to grant substantive relief. And so I think that that's how high the stakes were. And I was saying that before January 6th. After January 6th, no one down here in America essentially is doubting how fraud it was. Before January 6th, a lot of people were saying that warnings that our republic faced grave danger were just pearl clutching, was a phrase used. But I think that a deliberate, lawless attempt to overturn a presidential election would have and probably should have resulted in outright defiance.
Okay, thank you. Another question that came in here. Let's see, we'll go with this question from Derek Ross, who's here. And Derek says, other than necessary restrictions on defamation, what in your view are the appropriate limits that should be placed on free speech and expression? I think it's an interesting question.
Yeah, it's a great question. And again, I'm going to say, I think the United States, that our current constitutional structure is largely right. So defamation, for example, is not part of the freedom of speech. Child pornography, for example, is not part of the freedom of speech. True threats are not part of the freedom of speech. Incitement to violence, which is narrowly defined under American law under something called the Brandenburg Standard, is not part of the freedom of speech. And then there's other kinds of speech that, due to sort of the time, place, and manner of them, not because necessarily so much because of the viewpoint, but because of the time, place, and manner, and the effect on other, a time, place, and manner are kind of argument combined with the effect on others, such as hostile environment harassment. So American law prohibits hostile environment sexual harassment, hostile environment racial harassment, and that often involves words. It often involves, racial epithets. It involves, can involve sharing pornography at work, etc. Many different ways that something can be hostile environment harassment, and those words or those images might be constitutionally protected in another context. In other words, they're not per se unlawful, but contextually, in a workplace, for example, directed at a person when they're unwelcome and they become essentially, they're so severe, pervasive, that they become a term or condition of employment. That's an example of where speech is properly restricted. But American law does not recognize hate speech as a concept that says that there are certain words or certain ideas so repugnant that they can be banned, that they can be rendered unlawful. And I think that's a wise decision in American constitutional jurisprudence. So it is, I think we've largely, again, if you point to any given fact pattern, I'm going to agree or disagree, but I think we've largely drawn the correct lines, lines that are implied from the text of the First Amendment itself. So I think America is probably, I'm not an expert on free speech law globally. I do know that we're on a relative outlier in protecting freedom of expression. And one thing that I would say about the United States and the necessity of that within our system, we're a remarkably ideologically, religiously, politically, ethnically, racially diverse country, remarkably diverse. We have large communities representing virtually every kind of religious belief in the world. We have an increasing amount, as I said, of ideological diversity, increasing amount of ideological polarization. One of the ways I look at classical liberalism, and particularly rights of free speech and free exercise of religion, due process, not as creating a utopia. Of course not, they don't. I like what a pseudonymous writer named Scott Alexander said about classical liberalism. He said, it is the best Civil War avoidance mechanism ever created by the mind of man. In other words, it creates a space for extremely different and often opposed communities to live together in a shared republic. And what the First Amendment does is it gives people an opportunity to change, to seek change, and to hope for change through persuasion rather than through militarization. And I think that's an incredibly, and it's something that I think that we often sort of skip over, but that we're learning to appreciate more in the context of hyperpolarization in the US.
Okay, thank you. Got another question here. Alejandro, he asks, you observed that the federal judiciary successfully resisted the many election-related challenges to the rule of law. It's also been noted that Republican elected officials, with a few noble exceptions, did not, often out of fear of losing their jobs. Federal judges are appointed for life in the United States. By contrast, most state judges are elected. So question about this federalism here. Do you think elected state courts are vulnerable to putting electoral calculation ahead of the rule of law? Isn't security of tenure for judges essential to their independence?
I am a big fan of life tenure for judges as a general matter. I do think judges need to have let me put it this way, life tenure with a rigorous selection process. It's a different thing. It's kind of often hard to state how little Americans know about state judges, or how little Americans know about state appellate judges often, and how much of, and where I can see an argument for some regular opportunity for accountability there. I can see the argument, but I'm much more of a fan of judicial independence overall, much more. I don't think there's any perfect system, but that's the best of our options. So I'm much more appreciative of a independent judiciary. I will note that it wasn't exclusively federal courts that heard Trump campaign challenges. There were many state courts who heard them as well and rejected them. So there are many state judges who acquitted themselves very well during the election contest. But as a general rule, I think it's a better system to have maximum judicial independence from the political process. And we all know that judges do abuse that independence. And I do think there is, the federal Constitution does have a check of impeachment that is very rarely exercised, tends to only be exercised in cases of outright corruption. But I think judicial independence as a general principle is indispensable.
Okay, thank you. Yeah, we're moving through the questions here. Very good. Daniel asks, what should individuals do to help conserve the rule of law? It's a good question.
And this is, okay, so lawyers, the best thing that you can do is embody the values that you want the rule of law to represent. I mean, in other words, if you're going to have a choice between being Ken Paxton, the attorney general who filed the incredibly frivolous, potentially nation-breaking litigation at the Supreme Court, or as Solicitor General Kyle Hawkins, be Kyle. In other words, the rule of law depends on the integrity of the people within the legal system. That's something that I talked about a great deal. So we have to embody those values. Hold yourself to a particular code of conduct. Hold yourself to a particular standard. If you don't hold yourself to it, you're a poor vessel for trying to hold others. And I think that that's, this is a culture that is built from the ground up by individuals. And one of the things that it's no secret, no reason for you guys to know it, but I was very much an anti-Trump conservative during the last 5 years. And one of the things that I was happy to see is that the conservative legal culture had a lot of antibodies within it against Trump and against the influence of Trump or against the corruption of Trump compared to our political culture. Compared to the conservative media culture, the conservative legal culture had more antibodies. And part of it was because there was a particular kind of culture that was inculcated from the founding of the Federalist Society, a generation ago. And that the influence of Trump was counter to that culture. Now, that doesn't mean that had Trump won again and he had a second term as a president, that the Federalist Society culture was fraying. There's no question about it. Many members of the Federalist Society were among the attorneys general, state attorneys general, who tried to overturn an election. But the culture, though it frayed, and there were notable exceptions of people who deviated from that culture, it held. At the end of the day, it held. Would it keep holding for another 4 years? Pressures were immense. Would it keep holding if there was another 4 years of Trump followed by 4 years of Trump Jr.? I begin to get doubtful because there are plenty of lawyers out there who would do the bidding of their political patrons. Plenty, you can find them. But I do think that you have to be part of that culture dedicated to upholding the rule of law. That's the biggest thing that you can do as an individual. And when you do that as an individual, then opens up opportunities to advocate for that, to uphold that in the marketplace of ideas.
Great. Very interesting question here from Jason. And it's about outcomes-based reasoning and political movements. So he says, would you say that the outcomes-only based political movements on the left and the right in the U.S. Are they new phenomenon, or has it always been constantly present? And he asks, similarly, have process-based principles declined recently, or is it just as present as they have ever been in the whole of U.S. history?
So it's ebbed and flowed. I think that, one of the things that when you get a historical perspective on the Constitution and the fights over the Constitution, you know that there are always threats to the rule of law. There are always threats to constitutional liberty. There are always threats to the Bill of Rights. My favorite example of this is the exact generation that passed and ratified, that drafted and ratified the First Amendment, a few years later passed the Alien and Sedition Acts, which were acts that directly suppressed political dissent in the United States of America. These were the same, it was the same generation. So the founding generation violated its own constitution that it drafted and ratified. So this is something that there is a constant back and forth. And so you can go back in American judicial history and find a swings and counter swings throughout American history. And so I can't remember who said this quote. It's a really, and I'm going to butcher it. I don't have it right in front of me. And it's something to the effect, there are no lost causes because there are no gained causes. In other words, a lot of these arguments are never fully settled. They continue, and one side waxes in power, another side wanes in power. And I think that what you will have seen throughout American history are notable examples where an outcomes-driven process created massive injustice. Massive injustice. Dred Scott, for example, a Supreme Court case responsible as much as any other legal political development to the deepening of the oppression of slavery and hastened civil war. Korematsu, where Japanese Americans, in spite of the Equal Protection Clause, right there in the 14th Amendment of the United States Constitution, Japanese Americans interned involuntarily in enormous camps in the United States during World War II. Plessy v. Ferguson, again, in spite of the Equal Protection Clause and permitting separation of races in a way that was anything but equal. You can go through history and find these examples one after the other, but you also find time and time again, eventually, and often, sometimes it takes years, a response to that. But yeah, what I've noticed is people are not terribly focused on legal process, not terribly focused on the rule of law as an independent good in of itself, often judge cases entirely by outcomes. Did the side that I like win, or did the side that I would like lose? Lawyers can't do that. We can't do that. We have to look at reasons. We have to look at process. And when when we're only focused on outcomes, the history of that in the United States of America has been pretty pernicious. Pretty pernicious.
Okay, thank you. We have a bit of a comparative question here, and I hope I'm not going to put you on the spot. This is relevant for us as Canadians. And Daniel asks, do you think Trump would have caused more or less damage as a prime minister in a parliamentary system compared to the American presidential system? It's okay if you don't. That's a ornate question. Good one, but
more.
Yeah. Okay.
More. Okay, because raise your hand and say you're getting this wrong the instant I say something that's ridiculously wrong about a parliamentary system. But let's leave Canada out of it and go to Boris Johnson and Brexit. He had a fragile coalition before extremely fragile coalition. Such a fragile coalition that he had a hard time forming a majority to ratify his Brexit deal. Calls snap elections, wins a governing majority, and he can push that through. Once you have the governing majority in most parliamentary systems, the check on the power of the majority is minimal compared to the check on the power of the majority in the American system. So we have a system in the United States that is of divided government, of counter-majoritarian institutions, some of them engraved in the Constitution for better or worse, like the Electoral College, like the United States Senate, some of them as part of Senate rules, like the filibuster, and the ability of Donald Trump to work his will, especially to the extent to which he psychologically dominated the GOP throughout his 4 years in a parliamentary system, would have been far superior than his ability to work his will in our American system of separation of powers and with the multiple counter majoritarian. And now I know Trump was not a majoritarian president, but he had control of a majority of the government. He was able to accomplish only a fraction of the agenda that a prime minister who'd won election would likely be able to accomplish. And now a lot of people say that's a problem because when somebody they like gets in power, they find a lot of the roadblocks in their direction as well. I mean, there's checks and balance. I mean, there's positives and negatives here, and blocking a Trump that you might not like, the same mechanisms block somebody that you do like. So there's, I like our system, but I also know that it has its downsides.
Okay, that's good. We're coming up on to the hour here, so maybe we'll conclude with this question. I think this goes to your point, David, about Trump and the majoritarian and his success or lack thereof in politics. But Tunch asks, do you think proportional representation promotes the rule of law?
I don't think that's a question about the rule of law or not the rule of law. I think that that's more a question. There are an awful lot of ideas right now circulating in the American body politic about how to do something politically about American polarization. Okay, proportional representation. Some folks talk about that. Ranked choice voting, for example, is something that folks talk about. I am open to lots of conversations about political reforms that can help de-escalate American politics, because right now, I don't know if you guys have this perception north of the border, but every election in the US now is the most important election of our lifetime. Every election, the entire public is going to stand or fall depending on who wins or loses. I mean, I don't know how many times I heard Joe Biden will end America if he wins, because I live in a very red or conservative part of America that was resolutely opposed to Joe Biden. If you were in blue parts of America, you would hear that if Donald Trump won, the American Republic itself might be in danger. And so I am very open to political reforms enacted through legal process that can help deal with American polarization, increase federalism, like less authority to the federal government, more authority to the states, ranked choice voting that can maybe do something about this binary choice mindset that is dominating. Oh gosh, I mean, we can go through redistricting reform so that we don't have Jerry or gerrymandering, depending how you want to pronounce it, to where people are in hyper safe districts, to where their only concern is dealing with, if you're a right-wing legislator, your concern is holding off the far right. That's your only concern. Otherwise, you have a seat for life. All of these things, I think, are important things to think about in the context of dealing with American polarization. I'll connect it to the rule of law. I think you can connect it to the rule of law. that ultimately a high degree of polarization over time will degrade the rule of law. Because what ends up happening is it creates a situation where it's intolerable for your opponents to win. Intolerable. So if we keep polarizing, the rule of law will be a casualty. It will. Right now, it's holding back the beast, so to speak, but it will be ultimately a victim of the beast if we don't do something about polarization.
Okay. Well, I think with that, we'll conclude. It's been an hour. I want to be respectful of your time, David. Thank you all for coming to this. This was a really interesting discussion. We covered a lot of ground. I think we covered a lot of ground that's very relevant to us here in Canada. So I'll say thank you to you, David, for your time today. Really appreciate it.
It's fun.
I'll say thank you to Leonid for his time in introducing you and attending with us today. Thank you very much for your time, Leonid. And to the rest of you, thank you. Thank you for all your comments and have a good evening.
Well, thanks so much for having me. The questions were fantastic and I really enjoyed it. Thank you.
Thank you, David. Stay well.